Hey there, deep divers. Ever wondered, what actually happens when the government needs your property? Maybe for a road, maybe for something else. It's a really fundamental question about property rights, right? And it often gets wrapped up in some pretty dense legal talk. So today, we're going to try and cut through that complexity. We're looking at South Africa's new Expropriation Act 13 of 2024. This act, it was recently signed into law, though the start date is still coming. It's meant to bring clarity, a fair framework, to a process that, well, it affects everyone, really. Homeowners, big companies, you name it. Our mission today, to unpack its purpose, walk through the steps involved, get into that big topic of compensation, including, yes, the idea of nil compensation, and look at the fairness checks built in. So whether you're just curious or maybe a law student needing that aha moment, we'll guide you through it. Okay, let's dive in. Let's start with the big picture. Why? Why did South Africa need this new Expropriation Act? Why replace the old one from 1975? What's the driving force here?
Well, the core reason, it really goes right to the heart of South African law. Section 25 of the Constitution. You often hear it called the Property Clause. This new act explicitly says it exists to enable expropriation in accordance with the Constitution. So it's all about aligning the actual process with those fundamental constitutional principles.
Okay.
And making sure there's, uniformity across the country in how it's done.
So what are those core principles from Section 25?
Essentially, there are three big ones. First, nobody can be deprived of property arbitrarily, just, randomly or unfairly. Second, property can only be expropriated taken by the state for a specific reason, either a public purpose or in the public interest. And third, and this is crucial, any expropriation must come with compensation. And that compensation has to be just and equitable. It's either something agreed upon or, if not, decided by a court.
Just and equitable. That phrase sounds really central. How does the Constitution and now this act define that? What goes into figuring out that amount?
That really is the crux of it, yeah. Both the Constitution and the Act spell out key factors. They're not just pulled out of thin air. They look at things like, what's the property currently used for? What's the history? How was it acquired? What's its market value? Also, was there any direct state investment or subsidy involved in buying or improving it? And importantly, what's the actual purpose of this specific expropriation? It's meant to be a holistic view.
Right, a whole basket of factors.
Exactly. And this leads to another really critical definition in the Act, public interest. The Act is very clear that public interest includes the nation's commitment to land reform and reforms for equitable access to natural resources. And it specifically mentions addressing or redressing the results of past racial discriminatory laws or practices. That's a very powerful statement of purpose,
So it's definitely not just about building things like roads or dams. It's also fundamentally about tackling historical inequalities.
Precisely. It broadens the scope significantly. The Act also reinforces other rights, like the right to fair administrative action, lawful, reasonable process, and the right to have disputes sorted out fairly in court.
Okay, makes sense. It's about process and fairness.
Yeah, building a transparent, lawful system for everyone.
All right, let's shift from the why to the how. Practically speaking, what's the journey? If an authority needs property, what's step one?
Okay, so a key starting point. It's right there in Section 2, subsection 2. An authority generally cannot just jump straight to expropriation. They first have to make a genuine attempt to negotiate with the owner or whoever holds rights in the property, try to reach an agreement on reasonable terms.
So negotiation first.
Yes. Expropriation is framed more as a last resort unless maybe it's a really urgent situation. That emphasis on negotiation is a pretty important safeguard.
And before they even start talking negotiation or expropriation, what groundwork do they need to do? Do they just show up?
Yeah, definitely not. The Act demands a proper investigation first. Section 5 covers this. The authority has to check if the property is actually suitable for what they need it for. They have to identify all the registered rights, like the title deed, but also any known unregistered rights.
Unregistered rights? Like what?
Things like traditional or customary land use rights, maybe informal rights, things that aren't on an official register but are still valid rights. The idea is to get a full picture so they can figure out a just and equitable compensation offer for everyone affected.
Okay, and can they come onto the land to check things out? For surveys?
They can. Section 5 allows authorized people or valuers to enter for surveys and valuations, but, and this is important, it's not automatic. They need either the owner's written consent or they need a court order. So it protects the owner's space but still allows the necessary work.
Got it. Consent or court order.
Right. And they also have to consult with the local municipality and other relevant government departments like rural development, environment, water to understand the wider impacts.
Okay, so they've done their homework, consulted everyone. What's the first official letter or notice an owner gets?
That would be the notice of intention to expropriate, and it's a pretty detailed document laid out in Section 7. It has to be formally served on the owner, the bank, or bondholder if there is one, the mortgagee, and any other known rights holders. Plus, it has to be published publicly.
What's in this notice?
It's packed with info, a clear statement they intend to expropriate, a full description of the property, why they need it, the purpose, and the specific reason this property was chosen. It also gives proposed dates for the actual expropriation and when they might need possession. And critically, for you as the owner or rights holder, it must invite objections or submissions.
So you get a chance to respond.
Yes, within 30 days. And importantly, it must include an initial offer of compensation and explain how they arrived at that figure.
Okay.
It even asks the people who received the notice to tell the authority about any other rights holders they know of, just in case someone was missed.
That sounds quite thorough, trying to catch everyone.
It aims to be.
But what if someone is missed? Say, someone with one of those unregistered, maybe traditional rights. What happens then?
The Act has a process for that too, in Section 10. If you claim an unregistered right and you didn't get the initial notice, you can come forward. The authority then has to ask you for evidence of your right and how you calculate your claim for compensation.
Okay.
And here's an interesting bit, a practical point in Section 11. If the registered owner knew about an unregistered right but didn't tell the authority about it, yeah, they could potentially be held liable later if the authority has to pay extra compensation to that previously unknown rights holder because they weren't informed.
Wow, so that really encourages owners to be upfront about everything.
Exactly. Transparency on all sides is kind of built in.
Okay, so the authority has done the investigation, sent the intention notice, considered objections, dealt with any unregistered rights that came up. If they decide to proceed, what's the final step?
That's when they issue the formal notice of expropriation. Section 8. This one confirms it is happening. It repeats the property details, the purpose, and gives the final official date of expropriation and the date when the right to possess the property passes to the authority. On that date of expropriation, ownership legally vests in the authority. It becomes theirs. That's Section 9.
And what about those unregistered rights at this point? Do they just disappear?
Not automatically. Section 9 says all unregistered rights are also expropriated on that same date, unless the notice specifically says they are excluded.
Okay.
Registered rights, like a mortgage, usually stay attached unless they are also specifically expropriated in the notice. It's a subtle but important legal distinction.
Interesting.
Possession, though, the right to actually use the property, transfers on the date given in the notice or whatever date is agreed upon.
Right. Now let's get into what everyone always talks about. Compensation.
Yeah.
The money. We know it has to be just and equitable. What's the guiding principle there again?
Yeah, this is often the most debated part. The Act, just like the Constitution, stresses it must be just and equitable, reflecting a fair balance between the public interest and the interests of those affected. And it repeats those same factors we mentioned earlier from Section 25(3) of the Constitution: current use, history, market value, state investment, purpose of expropriation. Those are the key things to weigh up. Section 12(1) covers this.
Okay, now, this is where the conversation often heats up, as you said. The Act mentions nil compensation, zero. Can you unpack what the law actually says in Section 12(3)? Just the legal conditions, setting aside the politics for a moment.
Right. It's crucial to be precise here. Section 12(3) identifies certain specific instances where it may, and that word may is important, be just and equitable for nil compensation to be paid, but only when land is expropriated in the public interest and only after considering all relevant circumstances.
So it's not automatic.
Absolutely not. It's not a default rule. It outlines specific conditions where a court might find zero compensation appropriate based on that whole just and equitable balance.
Can you walk us through those specific examples the Act gives? This feels like a really core piece of information.
Sure. The Act gives 4 examples. They're illustrative, meaning there might be others, but these give a clear idea. First, undeveloped land, where the land isn't being used and the owner's main goal isn't development or income, but just holding it to benefit from rising market value, like pure speculation.
Okay, speculative holding.
Second, unused state land, where a government body holds land, isn't using it for its main job, probably won't need it, and importantly, got it for free in the first place.
Right, state land acquired for nothing.
Third, abandoned land, where an owner has effectively abandoned the land, hasn't exercised control, even though they could have reasonably done so.
Genuinely abandoned.
Yes. And fourth, where the market value of the land is basically the same as or even less than the value of direct state investment or subsidy that went into acquiring or improving it. So the state's input cancels out the market value.
I see. So the state essentially already paid for its value through investment.
In effect, yes. So these are very specific scenarios. It's not a wide open door. It's a set of conditions that might justify nil compensation, but always through the lens of what's just and equitable overall. And ultimately, a court would decide if challenged.
I imagine some listeners might still worry this could be used unfairly, maybe target certain people. How does the Act guard against that? What are the checks and balances?
That's a fair concern. The main safeguard is that constant emphasis on just and equitable, which has to be determined by a court looking at all the facts. The fact these are just examples means courts aren't bound by them. They have the final say. And don't forget the underlying constitutional rights fair administrative action, access to courts. These act as fundamental checks on any potential abuse of power by the authority.
Okay, that context is really important. Are there also things that specifically shouldn't be considered when calculating compensation to stop people trying to inflate claims?
Yes. Section 12(2) provides that balance. It lists things that generally don't count towards compensation unless there are special reasons. For instance, you don't get extra just because it was taken without your consent, or if the property has some special value that wouldn't likely be realized on the open market anyway. Also excluded is any value increase from using the property illegally, or, importantly, any improvements made after the notice of intention to expropriate unless the authority agreed to them.
So you can't quickly build something just to get more money.
Exactly. Or do anything else just purely to obtain compensation. It's about finding the fair value based on the situation before the expropriation process significantly impacted it.
This whole section really highlights that balancing act, doesn't it?
Yeah.
Individual rights versus broader societal goals, especially that historical redress element.
It absolutely does.
Okay, so we've covered the process, the compensation complexities. What happens if people just don't agree? Or if property is needed really fast?
Right, disputes and urgency. The Act has pathways for both. For disputes, Chapter 6, if the authority and the owner or rights holder can't agree on the compensation amount, the Act encourages them to first try mediation.
Mediation first.
They may attempt it, yes, Section 19(1). It's a step aimed at finding an amicable solution without immediately going to court.
And if mediation doesn't work, or they skip it,
then either side, the authority or the person disputing, can take the case to a competent court to decide the compensation. Generally, they need to do this within 180 days from the notice of expropriation.
in court, who has to prove their case? Is the burden on the owner or the authority?
Interestingly, Section 19(5) makes it clear. The burden of proof isn't automatically on one side or the other just because they were the one to start the court case. The court looks at the evidence from both sides to reach that just and equitable outcome.
Okay, fair enough. What about those urgent situations, like a natural disaster, maybe?
Yes. Chapter 7 deals with urgency. Section 20 allows for the temporary use of property if it's urgently needed for a public purpose or in the public interest, but it's strictly limited, usually for a maximum of 12 months, though a court could extend it to 18, and it's only if suitable government property isn't available.
What kind of situations qualify as urgent?
It's typically for disasters or truly exceptional circumstances that a court confirms, like a real and imminent danger to human life or substantial injury or damage to property.
So it's a high bar.
It is. And even though some normal procedures might be sped up or skipped in these urgent cases, the owner or rights holder is still entitled to just an equitable compensation for that temporary use.
If they still get compensated for the disruption.
Absolutely.
One more scenario. What if the authority starts the process, maybe even issues a notice, and then changes its mind? Can they back out?
Yes, they can. Chapter 8, Section 21 allows the authority to withdraw an expropriation if it's in the public interest to do so, or maybe if the original reason just doesn't apply anymore.
Are there limits on when they can withdraw?
There are. Generally, they can't just withdraw it after 3 months have passed since the notice, unless the owner agrees. Or if the property title has already been transferred or if compensation has been paid, again, unless the owner agrees.
And if they do withdraw it, what happens?
Ownership goes back to the original owner, Any rights that were ended are revived. And importantly, the authority has to pay for all reasonable costs and damages the owner incurred because of the whole process that was then withdrawn.
So there are consequences for changing their mind late in the game.
Definitely. It ensures accountability for the authority's decisions throughout the process. And speaking of accountability, the Act also mandates an expropriation register, Section 24. This has to be kept, maintained, and be publicly accessible. It lists all intended expropriations, ones that have happened, and any that were withdrawn. Transparency is key.
A public record of everything.
Yes. And finally, there are offenses and penalties in Section 25. Things like failing to provide required info can lead to a civil penalty. Willfully giving false or misleading information is actually a criminal offense, punishable by a fine or even up to 3 years in prison.
Wow, okay. So real teeth to ensure people provide accurate information.
It aims to ensure integrity from everyone involved.
It really sounds like they tried to think through a lot of the practicalities and potential issues. It points towards a law that's trying for efficiency, but also strong protection and accountability for owners. So there you have it, our deep dive into the Expropriation Act 13 of 2024. We've looked at why it exists, tracing it back to the Constitution. We've walked through the step-by-step process, from investigation to the final notice. We tackled the big issue of compensation, including those very specific examples where nil compensation might apply. And we covered the mechanisms for fairness mediation, courts, rules for urgency, and withdrawals.
Yeah, it's a really foundational piece of law for South Africa now. It's trying to navigate that complex space between individual property rights and the broader public interest, especially, as we've seen, relating to land reform and addressing historical issues. The goal seems to be legal certainty, a clear, structured, and fair process for something that can be incredibly sensitive and have a huge impact on people's lives. Of course, the big question moving forward is how this all plays out in practice. How will the implementation, particularly those provisions around nil compensation, actually shape property ownership, land distribution, and that goal of historical redress on the ground? That's something that will definitely continue to unfold as the Act comes into full effect and cases start working through the system.
A really important question to leave us with, something for you all to think about. We hope this dive helped clarify this complex act and maybe spark some new thoughts.
Thanks for joining us. We'll be back soon to explore another fascinating topic.